The difference between an informal agreement and a legally binding contract is enforceability. An informal agreement is two people saying, yes, that's how we'll do it. It might even be written down in a text message or an email. It might be completely sincere. But under BC law, for a real estate JV to be properly documented, it needs to meet specific requirements: signed, witnessed appropriately, and covering the essential terms. The gap between we agreed to this and we have a document that a court or mediator can interpret and enforce is where disputes live. And it's a bigger gap than most people think. Here's what I've seen go wrong just in the categories of we agreed but didn't write it down properly. Partner A believed she had decision-making authority over maintenance because she was the property manager. Partner B believed all spending decisions over $200 required joint approval. Neither was wrong based on what they remembered from the conversation. Neither had documentation to resolve the conflict. What followed was 6 months of tension, a formal mediation process, and a partnership that survived but would never fully recover the trust. That's the mid-range outcome. The bad outcome ends in legal action, which in BC real estate disputes can run into the tens of thousands of dollars and takes years. I want neither of those outcomes for you. So let's build your legal foundation properly. BC property law has specific requirements. What must be in writing? What must be signed? What provisions are required for an agreement to be enforceable? Your BC real estate lawyer knows these requirements and will help you make sure you're compliant. The most common issues: first, no written agreement at all, or the we trust each other verbal agreement. It's the most dangerous category. Second, a written agreement too vague to be useful, or the we'll split things fairly agreement. It will be costly to figure out what's fair in court, and it might not go your way. Third, missing provisions for life changes. If you don't have a plan for death, disability, or departure, you're in bad shape. Next, not having an exit mechanism is a recipe for disaster. And lastly, mixing business and personal finances is sure to cause trouble in status update meetings with partners or come tax or profit disbursement time. Any one of these can unravel a partnership, and together, they're almost certain to.